This is a dramatic reading of People versus Superior Court, in parentheses, no. California Court of Appeal, 2nd District, 1992. 5 California Appeal 4th, 822. 7th volume of the California Reporter, page 177. Ashby, acting presiding justice. Facts. The crime giving rise to the defendant, Sunja Du's conviction of voluntary manslaughter occurred on the morning of March 16, 1991 at the Empire Liquor Market, one of 2 liquor stores operated and owned by the defendant and her family. Although Empire Liquor was normally staffed by defendant's husband and son, while defendant worked at the family's other store in Saugus, defendant worked at Empire on the morning of March 16th so that her son, who had been threatened by local gang members, could work at the Saugus store instead. Defendant's husband, Billy Du, was present at the Empire Liquor Market that morning, but at defendant's urging, he went outside to sleep in the family van because he had worked late the night before. Defendant was waiting on 2 customers at the counter when the victim, 15-year-old Latasha Harlins, entered the store. Latasha proceeded to the section where the juice was kept, selected a bottle of orange juice, put it in her backpack, and proceeded toward the counter. Defendant observed many shoplifters in the store, and it was her experience that people who were shoplifting would take merchandise, place it inside the bra or any place where the owner would not notice, and then approach the counter, buy some small items, and leave. Defendant saw Latasha enter the store, take a bottle of orange juice from the register, place it in her backpack, and proceed to the counter. Although the orange juice was in the backpack, it was partially visible. Defendant testified that she was suspicious because she expected if the victim were going to pay for the orange juice, she would have it in her hand. 13-year-old Lakeisha Combs and her brother, 9-year-old Ismail Ali, testified that Latasha approached the counter with money, about $2 or $3 in her hand. According to these witnesses, defendant confronted Latasha, called her a bitch, and accused her of trying to steal the orange juice. Latasha stated that she intended to pay for it. According to the defendant, she asked Latasha to pay for the orange juice, and Latasha replied, "What orange juice?" Defendant concluded that Latasha was trying to steal the juice. Defendant began pulling on Latasha's sweater in an attempt to retrieve the orange juice from the backpack. Latasha resisted and the 2 struggled. Latasha hit defendant in the eye with her fist twice. With the second blow, defendant fell on the floor behind the counter, taking the backpack with her. During the scuffle, the orange juice fell out of the backpack and onto the floor in front of the counter. Defendant testified that she thought if she were hit one more time, she would die. Defendant also testified that Latasha threatened to kill her. Defendant picked up the stool from behind the counter and threw it at Latasha, but it did not hit her. After throwing the stool, defendant reached under the counter, pulled out a holstered .38 caliber revolver, and with some difficulty removed the gun from the holster. As defendant was removing the gun from the holster, Latasha picked up the orange juice and put it back on the counter, but defendant knocked it away. As Latasha turned to leave, defendant shot her in the back of the head from a distance of approximately 3 feet, killing her instantly. Latasha had $2 in her hand when she died. Defendant's husband entered the store upon hearing defendant's calls for help and saw Latasha lying on the floor. Defendant leaned over the counter and asked, "Where is the girl who hit me?" Defendant then passed out behind the counter. Defendant's husband attempted to revive her and also dialed 911 and reported a holdup. Defendant, still unconscious, was transported to the hospital by ambulance where she was treated for facial bruises and evaluated for possible neurological damage. At defendant's trial, she testified that she had never held a gun before, did not know how it worked, did not remember firing the gun, and did not intend to kill Latasha. Defendant's husband testified that he had purchased the .38 caliber revolver handgun from a friend in 1981 for self-protection. He had never fired the gun, however, and had never taught defendant how to use it. In 1988, the gun was stolen during robbery of the family store in Saugus. Defendant's husband took the gun to Empire Store after he got it back from the police in 1990. David Butler, Los Angeles Police Department ballistics expert, testified extensively about the gun, Smith & Wesson .38 caliber revolver with a 2-inch barrel. In summary, he testified the gun had been altered crudely and that the trigger pull necessary to fire the gun had been dramatically reduced. Also, both the locking mechanism of the hammer and the main tension screw of the gun had been altered so that the hammer could be released without putting much pressure on the trigger. In addition, the safety mechanism did not function properly. The jury found the defendant guilty of voluntary manslaughter. By convicting the defendant of voluntary manslaughter, the jury impliedly found the defendant had the intent to kill and the killing was unlawful, i.e., that it was neither justifiable nor excusable. Thus, the jury rejected defenses that the killing was unintentional and that the defendant killed in self-defense. Probation report. After the defendant's conviction, the case was evaluated by a Los Angeles County probation officer who prepared a pre-sentence probation report. That report reveals the following about the defendant. At the time the report was prepared, the defendant was a 15-year-old Korean-born naturalized American citizen, having arrived in the United States in 1976. For the first 10 years of their residence in the United States, the defendant worked in a garment factory and her husband worked as a repairman. Eventually, the couple saved enough to purchase their first liquor store in San Fernando. They sold this store and purchased the one in Saugus. In 1989, they purchased the Empire Liquor Market despite being warned by friends that it was in a bad area. These warnings proved prophetic as the store was plagued with problems from the beginning. The area surrounding the store was frequented by narcotics dealers and gang members, specifically the Main Street Crips. Defendant's son, Joseph Dew, described the situation as having to conduct business in a war zone. In December 1990, defendant's son was robbed while working at the store, and he incurred the wrath of local gang members when he agreed to testify on one of their number, who he believed had committed the robbery. Soon thereafter, the family closed the store for 2 weeks while defendant's husband formulated a plan, which he later realized was naive, to meet with gang members and achieve a form of truce. The store had only recently been reopened when the incident giving rise to this case had occurred. The probation officer concluded, "It is true, the defendant would be most unlikely to repeat this or any other crime if she were allowed to remain free. She is not a person who would actively seek to harm another. However," she went on to state that although the defendant expressed concern for the victim and her family, the remorse was largely centered on the effect of the incident on defendant and her own family. People v. Dew. Superior Court, Los Angeles County, 1991. Judge Joyce A. Carlin. Joyce Carlin sentenced Dew to 10 years in state prison, 6 for voluntary manslaughter, and 4 for use of a gun in the commission of a felony, a separate allegation, but then suspended the sentence and placed Dew on probation. The following are the judge's remarks at sentencing. Statements by the district attorney, which suggest that imposing less than the maximum sentence will send a message that a black child's life is not worthy of protection, are dangerous rhetoric, which serves no purpose other than to pour gasoline on a fire. This is not a time for revenge, and my job is not to exact revenge for those who demand it. There are those in this community who have publicly demanded in the name of justice that the maximum sentence be imposed in this case, but it is my opinion that justice is never served when public opinion, prejudice, revenge, or unwarranted sympathy are considered by sentencing court in resolving a case. In imposing sentence, I must first consider the objectives of sentencing a defendant. 1, to protect society. 2, to punish the defendant for committing a crime. 3, to encourage the defendant to lead a law-abiding life. 4, to deter others, and 5, to isolate the defendant so that she can't commit any other crimes. 6, to secure restitution for the victim, and 7, to seek uniformity in sentencing. The question becomes, are any of these sentencing objectives achieved by Mrs. Dew or being remanded to state prison? Let us start with the last objective first, uniformity in sentencing. According to statistics gathered for the Superior Court of California, sentences imposed on defendants convicted of voluntary manslaughter last year ranged from probation with no jail time to incarceration in state prison for several years. Because of the unique nature of each voluntary manslaughter, and by that I mean the uniquely different factual situations resulting in that crime, uniformity in sentencing is virtually impossible to achieve. Which then of the other sentencing objectives lead to the conclusion that state prison is warranted? Does society need Mrs. Dew to be incarcerated to be protected? I think not. Is state prison needed in order to encourage the defendant to lead a law-abiding life or isolate her so she cannot commit other crimes? I think not. Is state prison needed to punish Mrs. Dew? Perhaps. There is, in this case, a presumption against probation because a firearm was used. In order to overcome this presumption, the court must find this to be an unusual case, as that term is defined by law. There are 3 reasons why I find this an unusual case. First, the statute is aimed at criminals who arm themselves when they go out and commit other crimes. It is not aimed at shopkeepers who lawfully possess firearms for their own protection. Second, the defendant has no recent record, and in fact, no record at any time of committing similar crimes or crimes of violence. Third, The defendant participated in the crime under circumstances of great provocation, coercion, and duress. Therefore, this is, in my opinion, an unusual case that overcomes the statutory presumption against probation. Should the defendant be placed on probation? One of the questions the sentencing court is required by statute to ask, and answering this question is whether the crime was committed because of unusual circumstances, such as great provocation. I find that it was. I must also determine the vulnerability of the victim in deciding whether probation is appropriate. Although Latasha Harlins was not armed with a weapon at the time of her death, she had used her fists as weapons just seconds before she was shot. The district attorney argues that Latasha was justified in her assault on Mrs. Dew. Our courts are filled with cases which suggest otherwise. Had Latasha Harlins not been shot and had the incident which preceded the shooting been reported, in my opinion, the district attorney would have relied on the store security videotape and Mrs. Dew's testimony to make a determination whether to file charges against Latasha. Other questions I am required to answer in determining whether probation is appropriate are whether the carrying out of the crime suggested criminal sophistication, and whether the defendant will be a danger to others if she is not imprisoned. Having observed Mrs. Dew on videotape at the time the crime was committed and having observed Mrs. Dew during this trial, I cannot conclude that there was any degree of criminal sophistication in her offense, nor can I conclude that she is a danger to others if she is not incarcerated. Mrs. Dew is a 51-year-old woman with no criminal history and no history of violence. But for the unusual circumstances in this case, including Dew's family history of being victimized and terrorized by gang members, Mrs. Dew would not be here today, nor do I believe that Mrs. Dew would be here today if the gun she grabbed for protection had not been altered. This was a gun that had been stolen from the Dew family and returned to them shortly before the shooting. The court has been presented with no evidence, and I have no reason to believe that Mrs. Dew knew that the gun had been altered in such a way as to, in effect, make it an automatic weapon with a hairpin trigger. The district attorney would have had this court ignore the very real terror experienced by the Dew family before the shooting and the fear Mrs. Dew experienced as she worked by herself the day of the shooting. But there's things I cannot ignore, and I cannot ignore the reason Mrs. Dew was working at the store that day. She went to work that Saturday to save her son from having to work. Mrs. Dew's son begged his parents to close the store. He was afraid because he had been the victim of repeated robberies and terrorism in the same store. On the day of the shooting, Mrs. Dew volunteered to cover for her son to save him one day of fear. Did Mrs. Dew react inappropriately to Latasha? Absolutely. Was Mrs. Dew's overreaction understandable? I think so. If probation is not appropriate and state prison is warranted, then short prison term would be an injustice. If Mrs. Dew should be sent to prison because she is a danger to others or is likely to reoffend, then I could not justify imposing a short prison term.